Vincent is okay to let in from plaintiff's side? She's I'm not asking the peanut gallery, but a lot of people want Ms. Vincent in. All right. Good morning, Ms. Vincent. Can you hear us?
Yes, I can. Thank you.
No problem. If you behave, you get to stay in.
Okay.
Good morning, stenographer April. How are you?
I'm well. I hope all is well.
It's medium. There are a lot of people in court, so a little stressful, but I think we'll get through it. You should I'm Judge McBurney, by the way. It's nice to meet you, even though I can't see you. If you would please speak up if you have trouble hearing what's going on. I've told the lawyers that they need to be near a microphone, whether it's at counsel table or up at the lectern. So you just need to keep us honest if you have trouble hearing things, okay?
I appreciate that, Your Honor. Thank you.
No problem. So there are two more in the waiting room. BME, which I assume is Bondurant. I don't need to let the whole firm. Oh, that's you, person. Okay. All right. We'll let that in. And then there's one that says defendants exhibits. All right. Don't want to link your name to it. Just generic defendants exhibit. All right. Everyone's in. If there are others, one of your microphones isn't on. Who need to be let in from either side, just let me know, let Ms. Niles know, and we can admit people. Real quickly, stenographer April, are you ready to go?
Yes, sir.
All right, well, let's get on the record. This is case 2022 CV 367796. It is Sister Song Women of Color Reproductive Justice Collective and a bunch of other plaintiffs versus the state of Georgia. And we are here today and tomorrow for the bench trial of this matter. We're going to start in a few minutes with some argument on a motion to dismiss that the state has filed and a partial motion for judgment on the pleadings that plaintiffs have filed. But before we dive into that, I need to cover a few things. First, I appreciate very much how important this issue. Ooh, one other thing. I need to start the live stream. All right, we're back. I appreciate how important this issue is to many, many people, and that people are quite passionate about it. And for some people, it is very easily distilled into black or white. It's the right to life. It's a woman's right to choose. But as many of you in this room know, it's more complicated than that. There are a lot of complicated legal issues, and we have very, very good lawyers on both sides who are going to present those issues and some facts connected to them. If while you're in here you find that it is hard to be a dispassionate observer of the proceedings, I'd ask that you step outside until you can be dispassionate again. If there is any disruption, Deputy Gordon has been instructed, not by me, but by the sheriff, to make sure that the disruptor stays outside for the rest of the proceedings. I trust that's not going to be an issue. But we had virtual issues last time, and I would hate for those to infect any of the in-person proceedings. It is not a problem if anyone here, to include the many lawyers, as long as there is at least one lawyer from each side, for people to take breaks. We are going to have 2 long days, and we will move quickly and break infrequently and briefly when we break. But it is not a forced march, so if anyone needs to step outside, I can keep going as long as there is one lawyer at the bench, at the table for each side. We will break for lunch, I promise, but it's probably a truncated lunch. I also want to thank both sides for their Herculean efforts. I set an aggressive schedule because this is an issue that needs attention now and not in 3 months. It probably needed attention 3 months ago, but here we are. And I appreciate that both sides are very busy, that there is a whole lot in particular on the Solicitor General's plate. I'm not unmindful of that, but this is one of the most important things on his plate. And I appreciate that he has brought in additional resources so that we can move forward today and tomorrow. So thank you, both sides, for working hard on this and being ready to go. What we had discussed in a pretrial conference is that we would spend some time first to give both sides a little bit to address arguments on the state's motion to dismiss, as well as plaintiff's partial motion for judgment on the pleadings. And I'm happy to continue to do that. That's time away from the trial, but it's still time well spent. I do feel like the issues raised in particular on the motion for judgment on the pleadings have been discussed before, and not all of them, but discussed before and very, very thoroughly briefed. And I flagged that only to say it may be that the two sides want to spend a little less time with oral argument on that and rely more on their pleadings. But I'm not going back on my commitment to give you all about an hour across those two motions before we pivot to the trial itself. So what I'm going to do first is have both sides introduce their lawyers who are going to have speaking roles today. And then I will hear from one lawyer on each side as to what the plan is for those two motions before we get on into the trial. And I'll have my little countdown timer ready when it's time. So let's start first with counsel for plaintiff.
Good morning, Your Honor.
Good morning.
Julia Stone from Kaplan Cobb. I'm here with a lot of people who might be speaking today. So I've got Julia Kay from the ACLU. She'll be handling the argument portion of it. Tiana Mickelvet from Bondurant. And then in the next row, we've got Joanna Zacharias from the ACLU, Rebecca Chan from the ACLU, and Alice Wayne from the Centers for Reproductive Rights.
And at different times, different of these many lawyers may be involved with what's going on.
Yes, depending on the order of witnesses and how that all plays out.
Got it. Okay. Great. And Mr. Petrani, good morning, sir.
Good morning, Your Honor. Stephen Petrani for the state, of course. I'm going to be handling the motions argument at the beginning. Then I'm going to let my co-counsel introduce themselves for who's going to be talking throughout the day. I think there's some question as to who might be, depending on witnesses, of course, but I'll let them address that.
Sure.
I'm Gene Scher, and with me here is Chris Bartolomucci and Brian Field and Ed Trent.
Ed Trent is defendant's exhibits?
No,
Oh, no, back, further back.
Document.
Okay.
That's right.
All right. I thought I might link a name to it. Okay.
You can just call him Mr. Exhibit.
Mr. All right, DE, defensive end. All right, great. And I want to be clear, it is not an issue for people to be handing roles off. I just wanted to have some names to associate with faces, but if Mr. Bartolomucci is handling one witness and then Mr. Field is handling, that's all good. I just wanted to know who all was here and who might be doing things. And it will help stenographer April know who is doing what. So, Ms. Stone, has anything changed from plaintiff's perspective as to how we're going to start out today?
I don't believe so.
Okay. Same, Mr. Petrani?
Yeah.
Okay, and I can't remember if we said let's do motion to dismiss first or the MJOP. I'm fine with either. And were we going to try to spend about a half hour on each, or had you discussed how we're allocating that? And I want to be clear, I'm not going to say sit down, time is up. I'm trying to give you some framework so that you maximize the remaining time through end of today and all of tomorrow for the trial piece.
I think we're open to whatever Your Honor's preference is. I do think the state filed their motion to dismiss before our motion for judgment on the pleading, so kind of expected that one to come up first, but I'm
Okay.
happy, we're
Got it. We'll do first in, first up. Last thing before we begin with the state's argument on its motion to dismiss. As we discussed in our pretrial conference, because of the complexity of the issues and the volume of material that we will all be consuming from a very, very powerful fire hose, this is not the kind of trial where at the end of business tomorrow I'll be announcing the verdict, guilty, not guilty. Of course, it's not a criminal trial, but the two sides have asked to brief things, and the briefing schedule extends beyond November 8th. So I will not be in a position to rule on any of the many issues that have been presented and will be presented until after both sides have had a chance to brief, and we've agreed that some of the briefing will substitute to a certain extent for some of the examination that might have occurred during the course of a longer trial. So with that, Mr. Petrani, why don't you, and podium is all yours. Also, if folks for whatever reason are more comfortable being at the council table, if you're talking to a microphone with a green light on it, then the court reporter can hear you.
Thank you, Your Honor. I'm, of course, happy to talk about the void ab initio argument. Our motion to dismiss on that issue is essentially the mirror of the motion for judgment on the pleadings. One of us is right, one of us is wrong. Of course, we believe that we're right. I don't want to spend too much time on it, given that, as Your Honor mentioned, we already discussed it a couple months ago. There's been a lot of briefing on it. The only thing I think it's worth adding at this point is I think that in plaintiff's reply brief, they really made stark the distinction between our positions. On page 11 of their brief, they admit that under their theory, if Georgia were to enact prior to Brown versus Board of Education some, segregation sort of rule, it would not be void ab initio because the court had not ruled on Brown yet. That is just not the way constitutional law works. It was unconstitutional when it would have been enacted because the Constitution says that it's unconstitutional, not because you have to wait for the Supreme Court to give its opinion. There is the law, and then there are courts' opinions as to the law. And of course, the parties are bound to follow the court's judgments. But when it comes to its opinions, legislatures and everybody else can disagree, and they can fulfill their constitutional laws differently. And they are not bound to avoid legislating in that area until the court undoes its rule. And in fact, it's not clear how they could ever undo that rule if legislatures like the General Assembly are precluded from even passing a statute that would conflict with it. But I want to turn to essentially the substantive issue here. And while I agree with Your Honor this is an important case, I have to disagree that it's complicated. There is no right to abortion under Georgia's Constitution. There's nothing that even hints at a right to abortion under Georgia's Constitution.
So I agree. If you were to have a text of the Georgia Constitution and did a text search for the word abortion, it's not in there. There are a lot of words that aren't in there that are pretty firmly protected by the way due process, right to privacy, et cetera, have been defined by Georgia courts. So tell me why I know you didn't mean simply because the word's not in there, the protection's not there. But of course the analysis isn't that easy to simply look in the Constitution and it doesn't say gun in there. So how do we work through firearm rights? It doesn't say abortion, but there is a right to privacy. And maybe you were going there. But
yeah, Your Honor. So the right to privacy under Georgia law started in Pavasich in 1905, and that was very clearly a right to actual privacy, as that term is more colloquially understood, which is to say, my private affairs should not be exposed to the public. What plaintiffs are asking for is a much stronger and different version of privacy, which is not, I don't want my private affairs exposed to the public. It's what I do in private cannot be criminalized or cannot be prohibited. And the Georgia Supreme Court has only once in history issued a decision to that effect, saying that some conduct done in private cannot even be prohibited. And that was the absolute high watermark of privacy rights, and it doesn't even come close to reaching the conduct that we're talking about here.
This
And
is
so this is
Powell.
Powell, where the Supreme Court said that adult, consensual, non-commercial, intimate sexual behavior done in private is protected by Georgia's right to privacy. But there are a number of things here to point out. The first is how many caveats the court put on that, and in fact made very clear if any single one of those things is missing, it's not protected by the right to privacy. So if it's commercial, if it's non-consensual, if it's not between adults, people who can't legally consent, I mean, then we're all of a sudden out of the right to privacy. And one of the reasons that this was so easy for them to put all these caveats in there is that from the time of Pavicic, it's been exceedingly clear that the right to privacy, such as it is, only extends so far as you are not affecting anyone else. And so what the court in Powell said was, this is private because no one whose intellect is in a normal functioning condition would think that this is affecting someone else. It's just two adults in the privacy of their own home. We are
It's affecting someone else, but not adversely. I mean, it's two people. So
Yes,
it's affecting, but in a way because it's consensual, non-commercial.
Yes, exactly. If it's not consensual, it is affecting someone else, and then all of a sudden privacy does not apply. Same thing with commerciality and so forth. And so here we think that that's just the ball game. There is a third party involved. I mean, the legislature found that there is another person involved and wants to protect that other person. And I think the key point at the motion to dismiss stage is, first of all, plaintiffs don't even really challenge that. If you look at their briefs and their complaint, they actually very carefully avoid really disagreeing with that. What they say is, well, this new developing human is not fully developed, is still dependent on the mother. I mean, that's true, we don't disagree with that, but we disagree that merely being developing or being dependent on others has anything to do with this. Another point would be that even if there were a disagreement, even if the plaintiffs did for some reason think that a 6-week-old or an 8-week-old or a 10-week-old embryo or fetus was not a individual human being worth protecting, the legislature just gets to make that choice. There's nothing, plaintiffs have pointed to nothing to say that the General Assembly cannot find this is in fact a unique individual unborn child worth protecting. I understand plaintiffs disagree with this to some extent. They disagree as to the moral value and so forth, but these are all judgments that the legislature gets to make. And the argument from privacy assumes, in all of their briefing, plaintiffs skip past whether this is private at all. They immediately go to, well, you have to establish some kind of interest or whatever, and I want to talk about that too. But the first step, and this was very clear in Powell, is that you have to decide whether there's some sort of privacy right implicated here in the first place. And the one thing, there are a lot of reasons why a privacy right might not be implicated, but the one that is absolutely clear is if it's affecting some third party. And that's what the General Assembly decided, was this is affecting a third party, and we want to protect that third party. And to us, that's really just the end of the case.
So you don't think it's balancing, you think that there's nothing to balance because the decision to terminate a pregnancy, whatever phrase we want to use during these proceedings, because it clearly adversely affects what the legislature has defined as another life, then there is no privacy right, or it's just that the privacy right, that the balancing would come out, your argument, in favor of saving a life versus whatever, and we're going to hear a lot about it, the burdens or implications or concerns are for what would be pretty private about what's going on inside someone in their personal life and literally within their body. Are you saying it's just not a privacy right issue because it's other affecting, or?
Yes, you're right. Yes, so both. I mean, we have argument on the alternative that even if some sort of privacy right attached, this law would still be valid, and as I said, I do want to address that. But no, the first step is there a privacy right at all? And what the Supreme Court of Georgia has been clear, and essentially, I mean, there are essentially 4 cases, right? It's Pavicic, Zant, McAfee, and Powell. In all of those cases, the court was absolutely clear that no one else is being affected by this. There's no third party being affected. And once that happens, we're no longer in privacy land. And that's the first question to answer. And you don't immediately jump to, well, what if there was a right to privacy here? Because first you have to decide, do I need to do this analysis at all? Now I do want to address the second point, which is, okay, let's assume for the sake of argument, and we disagree of course, that there is a right to privacy that somehow affects this. Even there, I think that the law is clearly valid, and I think there are two key points here. The first is, plaintiffs assume that some sort of compelling interest standard applies, but actually if you read Powell, it just says it needs to be have a public purpose that's not unduly oppressive of the individual. That really isn't a compelling interest standard. It's kind of, if you look at the cases, it's kind of a rational basis plus standard, a little more than a rational basis, but not an immense amount more. But even going a step beyond that, we do think that even if we had to show some sort of compelling interest that was narrowly tailored, that we would, because these are unborn children that the state wants to protect, and there is no way of protecting them except to keep people from aborting them, essentially. And the arguments from the other side are basically that, well, you could do it in a less restrictive means by not prohibiting it at heartbeat. You could prohibit it at 15 weeks or 20 weeks or whatever, but that just misses the point of narrow tailoring. You're not vindicating the state's interest if you allow a lot of abortions the state does not want to allow, but just stop some at the back end. You have to actually stop the abortions that the state is trying to stop, and so we think that even if you get into some sort of a balancing test, the state clearly is still clearly has a valid law. But I also think that even trying to do that sort of a thing in this circumstance, I think shows why it's just not really, with all due respect, the judiciary's job to be making that determination, and why there is no privacy right here to begin with. I mean, these are essentially incommensurable values. The value of an unborn child versus the concerns of the mother or the family or whatever else might be involved. The legislature...
It's a little more than that. It's bodily autonomy. It's the mother who would be required to carry this child to term if the mother had been raped but chose not to tell the police about it because the person who raped the mother was her stepfather, who said, I will beat your mother senseless if you talk to the police about it. So now, under the current law, this young lady can't abort, even though it was a rape, because she chooses not to go to she doesn't choose, she is coerced not to go to the police. And so it's not just, well, what are the family concerns? It's how does it change this person physically and emotionally and the rest of her life, because she's 14.
Well, so Your Honor, when I say interest, I meant that broadly. I wasn't trying to minimize anyone's concerns, but I think...
But oughtn't that be weighed? I'm not accusing you of minimizing. You are a deep thinker about this, and so when I'm probing, it's to help me better understand it, because I know you don't want courts weighing things. That's not what they should be. It's the legislature. Let the legislature weigh. We're asked to weigh things all the time, and I'm not so sure that the right to privacy doesn't exist once something is other affecting, but it clearly is not all controlling. That's the law in probably all 50 states, but certainly in Georgia. It is no longer all controlling. That's what these cases say. But I don't know that the scale, if we're weighing things, goes to zero on the other side, because the act that the then mother would want to take would be other affecting. So
Your Honor, of course, that is our first argument, and I disagree. I think that if you look at these four cases, the Supreme Court is very clear that once it's other affecting, there is no right to privacy at that point. But even if we take a step past that, there's no doubt that the scenario that Your Honor lays out is is a heart-wrenching one, and what the best way of going about resolving that is, I think is certainly something that the legislature took into account. So I think that that's why they came up with the rule that they did. I think that even if the court thought that in these extreme scenarios there was some sort of constitutional problem, and again, we don't think there is, but even if, that's not talking about the 98% of cases, and plaintiffs are filing a facial challenge. So if they have an issue with some very narrow circumstance, that might be something to deal with on a case-by-case basis, but that's not what we're talking about when we're talking about a facial challenge. I also, point out that in most of these scenarios, there's this assumption that, well, an abortion would just solve everything. That sounds like a pretty horrific scenario to me, where an abortion does not solve everything. And so I think that it's very plausible that the legislature would look at it and say, look, we just don't think abortion is the way to solve the problems in this area. I mean, if you have that kind of abusive, terrible situation, there are ways to go about legislating, providing support, police, investigations, et cetera, that will actually help with these things, but we, the legislature, don't think that abortion is really the way to solve these particular points. But again, whether or not the legislature was correct on any given circumstance, the legal point is that because this affects another, privacy right doesn't apply in the first place. But even if we get past that and we say, okay, we're going to apply it anyway, we're in a scenario where the vast, vast majority of these cases are elective abortions that don't involve these kind of horrific facts that do, of course, make everyone sympathetic to basically every non-culpable party involved. And if you're going to challenge something facially as opposed to as applied, you really can't focus, as I think the plaintiffs really have done in their briefing, on all of the edge scenarios. And so I think that's one point there. Another thing about some of these edge scenarios, by the way, is, again, we don't think they really matter here because this is a facial challenge, but we also think that plaintiffs are just wrong about some of them. So the most obvious one is plaintiffs try to assert that under the law it would be difficult for women to get miscarriage care or something like this. And we think that's just a plain misreading of the law.
Okay, I thought that folks had sort of, on the sidelines, sorted that out. I'll let plaintiffs respond to that, but as I was reviewing the many pleadings, that seems to have been a position that plaintiffs have stepped back from a bit, from the language. I'm not committing them to that. I may have misread it. I want to be very clear, and they may want to come back full force on that, but that's not how I read the statute, and that might not be the edge scenario they're going to focus on quite as much.
If that's the case, Your Honor, I don't need to belabor the point. I just wanted to make clear to everyone involved, anyone who happens to be watching this, if you are experiencing a miscarriage, go get care. There's going to be nothing stopping you from getting care in this act. But just to get more back to the kind of the more general point, even if there were some problematic scenario, in a facial challenge, you have to show that in all, or at least essentially all applications, it's invalid. And so looking at these edge cases really doesn't help with that in any way, shape, or form. And so I think that would be our kind of final point. And on top of, there is no right to begin with here. Even if there's some sort of right, and at edge cases it might apply, it's not the sort of broad, essentially Roe Casey redux that would invalidate this law. It might have something to say on edge cases which can be litigated, on a case-by-case basis. And then finally, just very quickly on the record-keeping provisions, Your Honor, a couple of points on this. One is, this has been around for 50 years. This is not a new thing.
So that I'm following you, the record-keeping that the medical providers need to provide things to the district attorney's office?
Yes,
that
portion.
Okay.
Yes, Your Honor. So that portion of the statute has been there for almost 50 years. The only difference in the Life Act is that I believe they changed it from which district attorneys can request records. On that particular point,
So it could be that it's been unconstitutional for 50 years.
yeah, I mean, this is not an argument that it must be valid because it's been around a while. The point is just it's been around a long time, and no one seems to have pointed to any particular problems with it. And the main point I want to make on this is, as plaintiffs themselves recognize, there's no enforcement mechanism. And so they cite in their briefs, and I think this is correct, that what a DA would have to do is subpoena the records. And of course, once you have a subpoena involved, you can go to court and quash that subpoena. You can make all the arguments that they're trying to make here, except make them with actual facts in an actual case, where we can actually, apply the law to something less abstract than, well, might there be certain circumstances where this is unconstitutional? And I think that's particularly important here, where plaintiffs are trying to essentially assert the privacy rights of people who are not before the court. And even if we assume for the moment that they have standing to do that, it just seems like a very bad idea to say I'm going to facially invalidate this law based on the privacy rights of people who might actually not like this. They might want DAs to be able to get these records, and there's no privacy problem at all, and this is totally constitutional as applied in that case. And so, although we do think...
How would person X know that person X's medical information, intimate, detailed medical information, is being disclosed to the DA of County Y? Let's say a subpoena was used, so Hospital Z gets the subpoena. They choose not to fight it. That would be a natural, I want to quash this. I'm not, HIPAA, all sorts of reasons. I'm not, the hospital, I'm not disclosing it. But I'm patient X. I don't know that a subpoena has been dropped on the hospital. I didn't know the hospital was going to share the details of a procedure that I don't want anyone to know about with the district attorney, someone I didn't vote for and I don't like, or whatever the situation might be. How does someone get to stand up and say, wait a minute, I want to invoke my privacy rights to my medical information that is being handed over just on a subpoena? It's not even particularized. The DA presumably would say, give me every abortion that you did, Hospital Z.
Yeah, so, Your Honor, I think in any given case, I'm not necessarily sure. I mean, to be entirely honest, I'm not sure. That's kind of part of the reason I think a facial challenge is a problem. I think most of the time, medical providers are going to say, whoa, hold on, we're not just handing out medical information without at least contesting this or letting someone know and so forth. But I don't think that plaintiffs here are in any better position to kind of speak for those people than the hospital would be or the clinic would be. So I don't doubt there are some kind of weird issues around this. It's a statute that, as far as I can tell, hasn't been used very much. And so there isn't much kind of explication of it. But this is, if anything, this is our point. Like, facially, invalidating a statute where there are clearly going to be valid applications, and where there is nothing in front of the court now that would be any different than when a DA actually requests something like this, and then the hospital could contest it at that point. It just seems to me like, even if plaintiffs have standing in the constitutional sense, it would be highly imprudent to try to decide this issue across the board on what is essentially speculative concerns. I mean, we don't really know how this is going to operate in practice, and we don't know whether patients are going to want or not want their information to be provided. It could all be anonymized or things like this. I mean, that might be the kind of requests that the DA is making, and we just don't know.
But it's not required.
No, it's not.
The DA could say, give me all the gory details.
Yeah, I mean, I do think it's relatively limited. I think it has to be just about abortion. I mean, I think given its place in the statute and so forth. But again, this is something where I think we actually do acknowledge that there might be certain people in certain circumstances who this could be a problem for. Don't know what the circumstances would necessarily be, but it's certainly not before us. But it's certainly not every person in every circumstance in a way that would make sense. Kind of go out and decide this way ahead of time for all cases for all time. So that would be my final point there. I'm of course happy to answer any other questions Your Honor has. Otherwise, I can sit down and we can move forward.
All right. If I have more questions, I'll send them your way.
Thank you.
Ms. Kay.
Good morning, Your Honor.
Good morning. So, Mr. Petrani, 90%, 95% was about motion to dismiss. It was a little bit about void ab initio. I assume you're going to focus just on motion to dismiss, or are we sort of covering both right now?
So my intention, Your Honor, was to begin with the state's motion to dismiss, and then I can either pause and give Mr. Petrani a chance to respond, or I can go directly into void ab initio.
We'll do the latter.
All right, thank you. So, Your Honor, first, just as a preliminary matter, The state filed its motion to dismiss 3 days after filing its answer. That's a violation of 911-12B and would be an independent basis to deny the motion.
How is it meaning it was too soon or too late?
It was untimely, it was late.
Okay.
A motion raising defenses, including failure to state a claim, has to be raised before or at the time of the answer, and as Your Honor noted in the order denying the motion to cancel the trial, it was untimely. But let me focus on what we're really here to talk about, yes. The question is whether forced pregnancy infringes Georgians' fundamental right to privacy under the state constitution. And there are really two pieces to that.
Is there a difference between right to privacy and fundamental right to privacy?
I'm using the language of the case law, Your Honor.
Okay. But I just want to make sure, I mean, it is a fundamental right, no question. I just wasn't sure if you were distinguishing that from, the plain old right to privacy. It is the right to privacy, which is fundamental.
Correct,
Okay.
exactly. So there are really two pieces to this question drawn from the case law. The first half is, would a reasonable person think that forcing someone against their will to go through pregnancy, labor, delivery, and in most cases a lifetime of parenthood interferes with Georgians' right to be let alone and to the uninterrupted enjoyment of their life, body, and health?
I'm not familiar with the reasonable person test.
That language is in Powell, and it's actually, Mr. Petrani alluded to it as well, that the court was questioning, is this what most people would view as something that falls within the area protected by the right to privacy?
Okay.
And
so
then-
I know I'm interrupting you a lot, but I want to just understand the questions I had. And
Of course.
you'll be able to cover everything else you want to cover. Viewed through the lens of the mother, very reasonable question. And you laid out all of the implications, not consequences, they are consequences, but implications of carrying a child to term and then likely, very, very likely, raising that child, whether you're age 13 or 33 or whatever. Viewed through the lens of the person that the legislature has deemed exists once a fetal heartbeat is heard, the answer there is you're killed. How do you balance those two?
So that's actually the second half of the question. And again, I'm tracking the language of the precedent, which starts with, is this within the sphere of the privacy right, and then gets to the question of, is there a neighbor's rights that
Right.
this is starting to impede upon?
We're in the sphere.
So I'm starting, right, that we're in this sphere. And let me just pause there and say, this is an easy question. First of all, for purposes of the motion, the allegations in plaintiff's complaint must be taken as true, and we detail how profoundly intrusive and medically dangerous it is to force pregnancy and childbirth upon someone. When Pavicic found that even the unauthorized taking of a picture of your body is a violation of the right to privacy, it is inconceivable that an intrusion of this magnitude, that forced pregnancy and childbirth, is not implicating the right, is not within the sphere of privacy, implicating the right to be let alone and uninterrupted enjoyment of your life, body, and health.
So it's interesting. You would call almost another way to look at it is Pavicic is sort of the high watermark of privacy. It's a violation of your privacy just for someone to take a picture of you. And here we're talking about all the other things you've described, which are clearly far more invasive and intrusive and life-altering than someone taking a picture. So if you are protected from someone taking a picture of you you don't authorize, certainly you are protected by the right to privacy from the many, many things that you've detailed.
Yes, exactly, Your Honor, although I take issue with the state's discussion of the high watermark of Georgia's constitutional right to privacy. Georgia has a rich, a storied history of pioneering the right to privacy, and that is a thread that has been present throughout the case law for over a century.
You say that, but there really are just so few cases. When Mr. Petrani ticked off the 4 cases, like, yeah, those are the 4 I'm aware of. And I assume if there were 100 others, you guys are very good with appendices and footnotes, and I didn't get that footnote of the 128 cases from the Georgia Supreme Court creating that rich body of right to privacy law.
Yes, Your Honor, but I'm quoting virtually verbatim from Powell. Since Pavicic, the Georgia courts have developed a rich appellate jurisprudence in the right of privacy, which recognizes the right of privacy as a fundamental constitutional right.
It always sounds good when judges write it. It doesn't always mean it's so, but got it.
But so let me turn to the second question, which is really where the dispute is. The state argues that it doesn't matter how grave of an intrusion this is. Once there is a fertilized egg, in the words of the state, that's the ball game. You don't do any balancing. That means that the state has a free pass to impose this tremendous intrusion onto Georgians' lives, bodies, and health without having to show that what it is doing, that the particular means of serving its compelling interest is the least restrictive means of doing so. Based on the allegations in the complaint and Georgia Supreme Court precedent, that is simply wrong. Now, the state relies on Pavicic's language that my privacy rights end where my neighbor's rights begin. This language about neighbor. And Pavicic and Powell both refer to other individuals as being the outer limits of the privacy right, and Zant uses the phrase third party. So let me just start with the allegations in the complaint, paragraphs 59 to 62, which talk about the process of a pregnancy developing. And what is clear is that for at least the first 5 months of pregnancy, the zygote and then embryo and then fetus is entirely subsumed by, attached to, and dependent on the pregnant person's body and could not survive outside the womb even with the best medical devices you could imagine. That is very far from a neighbor, just focusing for now on the allegations.
So, okay, so you're working through the allegations, but just back to the law, because I think even some of the defense experts would agree with that science that you've described. I hope most of them would. But that's not what the legislature has said. And so where is it that the legislature is impermissibly overstepping its bounds to say, science is fascinating, but the earth isn't as round as you think. Life begins at fertilization or fetal heartbeat. And once you're there, that's the equivalent of a walking, talking, voting, majority age individual, and you may not impinge on that person's rights. And that 6-week-old fetus that looks more like a little reptile curled up enjoys the full panoply of rights that you and I, you're not a Georgian, but that
My colleagues.
your colleagues and I enjoy as Georgian citizens.
Your Honor, the legislature does not get to dictate the meaning of the Constitution. That is crystal clear in in-re judicial qualifications. So the legislature's determination that a fertilized egg is a person that should have equal status under the law as the pregnant woman carrying that fertilized egg is irrelevant to this stage of the constitutional question. The state's interests in protecting a zygote or an embryo or a fetus, absolutely part of the analysis, but it comes later. Right now, we're just establishing, is the right to privacy of the Georgia Constitution infringed? And is a fertilized egg, does that rise to the level of a neighbor under the Georgia Supreme Court's precedent?
And it's that last piece that I want you to focus
Yes.
on, because I think for purposes of a motion to dismiss, you clear by 100 yards the hurdle of, is there a right to privacy? Is it infringed by requiring a woman to carry to term the pregnancy? Where I think the legal, for me right now, the legal struggle is, well, what about that other person, fetus? And the legislature has said, treat it as a person for purposes of the legislation that was passed. So that's where I'm wrestling right now.
Absolutely, Your Honor. And I just want to underscore again that this, as the state is framing it, the first half of this inquiry is black and white. In the state's telling, as soon as there is a fertilized egg, that nullifies the pregnant person's rights. And in our understanding of the precedent, the first question is whether the right to privacy is implicated, and then you get to the balancing once you're applying strict scrutiny. So let me turn to the case law that guides the court's understanding here. So the language of a third party being the outer limits of the right to privacy comes from Zant, and Zant cites to Jefferson for this point. So Jefferson is central and very instructive, and it indicates that viability is the key milestone when the interests of the fetus may override the constitutional freedoms of the pregnant person. Nothing in precedent suggests that as soon as a woman becomes pregnant, that her rights disappear. So let me focus on Jefferson. Jefferson involved a Jehovah's Witness who was in her 39th week of pregnancy, full-term pregnancy, 39 weeks. And because of her religion, she objected to undergoing a C-section delivery. There was no dispute that if she did not undergo the C-section, there was a virtually 100% chance that this full-term fetus would not survive. And there was a 50% chance that she herself would die. And so the hospital went to court to say, can we force this woman to go through the C-section delivery to save really both her life and the life of the fetus? And the court recited the fact findings of the trial court, the Supreme Court recited the fact findings of the trial court, which emphasized repeatedly that this was a 39th week pregnancy. This was well beyond the point of viability and the point of being able to survive outside the pregnant woman's body. And then critically, in holding that the hospital could require this surgery, the Supreme Court cited to 3 cases. First, the court cited to Roe v. Wade, which of course held that up to the point of viability, you could not override a pregnant woman's right to privacy, but after that you could do so, although there had to be an exception for her health. It cited to a case out of the New Jersey Supreme Court, which emphasizes in the very first paragraph that it was a similar fact pattern that emphasized in the very first paragraph that the pregnancy was in its 32nd week. And it cited to a case involving a medical dispute between adults. So you look at the cases that the Supreme Court was relying on, and you have to draw from that viability, or something closer to the very end of pregnancy, that is the critical point when the balance of interest might shift. So when Zant talks about a third party and cites to Jefferson, there is nothing in Georgia precedent that would suggest that a fertilized egg or an embryo at 6 weeks is that neighbor or is that third party. Now,
So
yes.
you are relying on Zant's reference to Jefferson, Jefferson's emphasis on viability as the constitutional interpretation and application that would be the higher court saying, here is where the other affecting nature of a private action starts to be weighed, and not earlier. And because that is constitutional interpretation and application, it's fascinating that the legislature said what it says, but the legislature doesn't define what the Constitution means.
Exactly.
Okay.
Exactly. And I would also point the court to the fact that Powell relies on Campbell v. Sundquist, which is a decision out of Tennessee that reaffirmed a fundamental privacy right under Tennessee's Constitution not to procreate, and permitted someone to destroy frozen embryos so that he would not be forced to become a father against his will. There is nothing in Georgia's rich history of the right to privacy that would suggest that Georgia's Constitution is any less protective. Now, I'd like to turn to the application of strict scrutiny. And first, I just want to make clear that once the right to privacy is implicated, it is the state's burden to show that its intrusion furthers a compelling interest through the least restrictive means. And if the state cannot do so, the law is facially unconstitutional.
So 2 things on that. One, what are your thoughts about the rational basis plus rather than strict scrutiny? In the language of Powell that Mr. Petrani was talking about, do you think that he was mischaracterizing, and I don't mean that in a pejorative way, but his interpretation of Powell and the level of scrutiny that is to be applied was that it's not strict scrutiny, that it is something less. It's more than rational basis. It's one of those like clear and convincing evidence, whatever the heck that means. It's not by preponderance. It's not beyond a reasonable doubt. It's in between.
The state is wrong. At page 333 of Powell, the court says, this court has concluded that the right of privacy is a fundamental right and that a government-imposed limitation on the right to privacy will pass constitutional muster if the limitation is shown to serve a compelling state interest and to be narrowly tailored to effectuate only that compelling interest. The state cannot meet that heavy burden. The Georgia Supreme Court has been clear that the state can't just assert an interest in human life in the abstract and that ends the matter. We saw that in Zant, we saw that in McAfee. Instead, the interest must be sufficiently compelling under the circumstances of the case to override competing rights. And this is where Jefferson again is instructive. Jefferson indicates that the earliest point at which that balance might shift over is the point of viability. I would note that pre-existing Georgia law is effectively the viability line. Pre-existing law banned abortion at 22 weeks as dated from a patient's last menstrual period, and that is the earliest point when viability is possible under optimal medical conditions. We have that in our
When you say pre-existing, pre-Life Act, not
correct.
There's a lot of pre-existing Roe, Dobbs, but we're referring.
Yes.
Okay.
Yes,
Pre-Life Act.
before HB 481,
Okay.
exactly. And this was the state of the law until July 20th, 2022. Now, even if the court were to find that the state did have a compelling interest in protecting an embryo beginning just 2 weeks after a patient's last menstrual period, the grossly inadequate exceptions make clear that this sweeping ban is far from the least restrictive means, and to the contrary, the legislature seemed to have taken the maximally restrictive course at every turn. So I'm not going to go through each of these because we've had a lot of briefing on it, but I just want to highlight two examples, which is the exclusion of life-threatening psychiatric emergencies, that the state is saying even if you are going to commit suicide unless you can end this pregnancy, tough luck. And I would also point to what Your Honor mentioned earlier, which is the police report requirement for a rape victim.
So let me ask, Mr. Petrani referred to those as edge scenarios, and I'm sure the witnesses will help us better calibrate how infrequent or seldom those two scenarios. I will kill myself because I'm right now not emotionally stable or mentally stable if I have to move forward with this pregnancy or the child rape situation. So we don't need to go back and forth about that, whether that's 1% or 5% of all cases where a woman seeks an abortion. Assume for a moment those are edge scenarios, not to suggest they aren't crises and merit attention, but Mr. Petrani's argument was it's a facial challenge, and so you can't handpick the scenario I brought up of a 13-year-old raped by her stepfather, not quite incest, it's rape, and for all sorts of reasons, she said, I'm not going within 1,000 yards of the police on this one, because he'll just beat my mom again. Then she's stuck. No relief under the current law. And that seems like the wrong outcome to lots of people. But if that's 1 out of every 10,000 situations, and the heartland of cases is, for very personal and important reasons, I'm electing to end this pregnancy, but there's no coercion, duress, or whatnot, and now I can't because it's week 10 or week 15, isn't that sort of the heartland? And so if it's a facial challenge, that's what you should be addressing, and not the woman who is at risk of self-harm, suicide, or the 13-year-old whose stepfather raped her.
Because we're applying strict scrutiny, it's the state's burden to show that they used the least restrictive means possible of furthering their compelling interest, and if the state cannot meet that standard, the law is facially unconstitutional. A law that is going to force a 13-year-old raped by her stepfather to carry that pregnancy against her will, a law that's going to sentence mentally ill Georgians to death because they're not permitted to end their pregnancy, that is not possibly the least restrictive means. So the percentage, the frequency doesn't matter, because what matters is that the Georgia legislature did not tailor this properly.
Okay, your point is that because these very real edge scenarios, lower percentage occurrence rate than something other, because they are captured by the reach of the current law, that shows that if it could be sufficiently narrowly tailored, don't know that it could be, but if it could be, it hasn't been, and that's fatal.
Precisely.
That's your argument.
Yes, exactly. Now, I just want to pause for a second on miscarriage. So,
And I want to be clear, I was not binding your clients to any position already. I had thought that there had been some back and forth about if you are in the midst of a miscarriage, you can go to any doctor and that doctor can help you work through that, and it does not implicate HB 40. But
there have not been side conversations on that, Your Honor, and I appreciate you raising it, because it gives me an opportunity to point out. You will hear later on today from witnesses about the terrifying ambiguity as to what is permitted with respect to miscarriage care and how that is actually playing out right now for Georgians in those traumatic circumstances. What we need is either a stipulation or a partial settlement from the state or a binding interpretation from this court as to what is permissible in the context of an inevitable miscarriage. Because the language of the law says it's not an abortion if you're removing a dead fetus. And so the state has said, well, the medical futility exception would apply there. We are all for an interpretation that would make this law less devastating and dangerous, but what the state says in its papers is not binding. And there are criminal penalties, as you know well. So we need greater clarity on that. Very briefly on the records access provision, I will just note that as we put in page 26 of our opposition to the motion to dismiss, there is a threat that failure to comply with a district attorney's request for the patient's medical records would mean that someone is held in contempt and potentially imprisoned. The state said, oh, well, it's clearly just the abortion information that will be made accessible. But what HB 481 says, and also the pre-existing law says, is it's the patient's health records that are made available. Once you have your abortion, your health records are available, and we have allegations in the complaint that your health records, and as we all know, your health records contain what medications you're taking, your sexual history, your mental health status, and a tremendous number of deeply intrusive and personal matters. That is exactly why in King v. State, which is directly on point, the Georgia Supreme Court held that prosecutors can't access those deeply private medical records without due process protections like a subpoena. You just don't get to do dragnet fishing of abortion patients' medical records. That's all I have on the motion to dismiss. Unless Your Honor's further questions, I'll turn to void ab initio.
let's turn to that. I'm mindful of the time and also mindful of the extensive briefing that has happened.
Yes.
And I also know that if while I'm working through this, I've got a question, I can always reach out to both sides and guarantee myself more briefing. So,
Absolutely. If you want more paper, we are sure happy to provide it.
yeah, Georgia Pacific appreciates you guys.
So, the Georgia Supreme Court has emphasized time and again that void ab initio is assessed based on the law's constitutionality at the moment of enactment. In Adams, the court held that to answer this question, you look to the court interpretations that were governing when the law was adopted. This state does not contest our explanation of the legislative history of Adams, which makes clear that what the court was looking at in Adams, what it referred to as the original year support statute, is the 1958 statute that before it was amended in 1979 in an attempt to comply with the new decision in Orr v. Orr. I want to make clear that we know that the original year support statute is referring to that 1958 statute and not to some earlier pre-14th Amendment version, because the court then goes on to refer to the earlier year support laws. If original meant first in time, you wouldn't distinguish it from something that in fact came earlier. So what's critical is that the court is saying, in 1958, the 14th Amendment existed, but it hadn't yet been interpreted to prohibit sex discrimination, so we're not going to say that the legislature did anything wrong. We're stepping into the minds of what did the legislators know about the state of the law when they adopted this, and they did nothing wrong because at that time the law did not prohibit these kinds of gendered spousal support
More
laws.
importantly, what the court in Adams didn't say was, well, the law is always the law and it's never changed, and we've had the vision now to tell you what it means, and so retroactively it means what we say now it means.
Exactly.
How does it work if some of HB 481 is deemed void ab initio? Is all of it? Is that why, I understand why you don't necessarily embrace Life Act as the name. It's kind of confusing for the references in all your pleadings to be to HB 481 and its sections, because of course you can't search for that, and that's actually not the law. The law is 1612, 141, and the other provisions. So twofold question. One is just procedural. I'm curious why, other than you may not like the nomenclature, why your pleadings focus on the sections of HB 481. Of course, that's the act, and if something's void ab initio, that's what would have been void, the thing that was passed. So explain that, but more fundamentally, I'm curious to know your view as to what happens if a court finds that, and I'm making the section numbers up, section 4 of HB 481 is void ab initio, but the other things aren't, because at the time passing that didn't violate any understanding that we had at the time of the federal or the state constitution.
So I would point the court to the citation at the top of page 15 in plaintiff's motion for judgment on the pleadings, which cites to in the interests of RAS, where the Georgia Supreme Court explained where a statute is held to be unconstitutional and void in part, a subsequent constitutional amendment cannot revive the void portion. So the court can simply hold that the provisions within HB 481, the three sections that we point to, which are all related to the 6-week ban, that those were void ab initio, but the rest of the statute is fine.
Okay. So there can be sort of that blue pencil surgical, here's the part that at the time this law was passed was plainly unconstitutional under everyone's understanding at the time, meaning the Supreme Court of Georgia and the United States, if that's how this plays out, but other provisions would persist.
Exactly.
Okay.
The state is raising in its briefing and in earlier argument 5 alarm bells about applying void ab initio here.
Meaning 5 different bells or a really, really, really loud alarm?
A really, really, really loud alarm.
Okay.
The state's parade of horribles is unfounded, and let me articulate briefly why. The Georgia Supreme Court has not hesitated to require reenactment, even when it might seem harsh or perfunctory. So in Jones and in Wilkins, the legislature passed a law that was void at that time, realized their mistake, one day later went through the whole rigmarole to cure the constitutional defect, and the Georgia Supreme Court said, sorry, you can't revive it because it was void from the start, you have to reenact it. So the state, you saw in the state's briefing this reference to plaintiff's contrived rule. This comes from the Georgia Constitution and the Georgia Supreme Court's application of the voidness provision in the Georgia Constitution. The second reason why the state's concerns are overwrought is that this is a very unique fact pattern. It's not like the General Assembly frequently passes laws that, are an effort to test the U.S. Supreme Court's clearly established precedent in a given area, and it is even much less frequent that the Supreme Court would then go on to overrule that very precedent. So requiring reenactment under these circumstances is no great burden on the legislature, and as noted, it is required by binding precedent. Now, I'd just like to close by highlighting language in Sherman v. Atlanta Independent School System, which is 293 Georgia 268. And this is just from 2013, which I think well illustrates the democratic accountability principle that's animating this doctrine. In Sherman, the facts are that the legislature had enacted a law that was unconstitutional under court interpretations of the time. The people of Georgia then ratified an amendment to the Constitution to not only permit those kinds of laws moving forward, but also to specifically give that once unconstitutional law retroactive effect. In explaining why the void ab initio doctrine does not apply to prevent such retroactive effect, the Georgia Supreme Court emphasized that there is a key distinction between, on the one hand, the legislature's power to pass laws which are limited by the Georgia Constitution, and on the other hand, the power of the people of Georgia to ratify changes to the Constitution, including a specific exception to the void ab initio constitutional provision applied to a particular set of facts. And what's really key is Sherman explained that it is, and I'm quoting, an essential aspect of our system of government that the people, not the judges, have ultimate control over the law under which they live. That is perfectly aligned with the Georgia Supreme Court's reenactment requirement. So if a law is void ab initio, the people of Georgia can revive it by ratifying a constitutional amendment that says we're going to give this retroactive effect. Or if there is some other change in the constitutional landscape, as in our case here, the legislature can reenact a law that was void if that is the people's will. But a change of heart by 5 justices on the U.S. Supreme Court is not enough to revive a law that was void under the Georgia Constitution, because it is the people, not the judges, who have ultimate control over the law under which they live. The General Assembly is free to take a vote and reenact a 6-week abortion ban now that Dobbs is the law, but Georgia's Constitution requires that the people have an opportunity to weigh in.
Got it.
Thank you, Your Honor.
Thank you. Mr. Petrani, you've got a little bit of time. You can respond to the arguments on the motion to dismiss. You can talk more about void ab initio. You can say, you know what, you've heard it all, however you want. You get about
just
15 minutes.
Very quickly, Your Honor. First, on the 9/11/12B point, we filed both things at the same time, served them on plaintiffs at the same time, made sure Ms. Niles had them at the same time. The clerk's office apparently kicked one of them out. So we filed on a Friday, they kicked one, and so we refiled as soon as we could. Apparently there was an F in the caption where it should have said in, it said fin. So we did, in fact, try to file them at the same time. But just setting that aside, just a few points. First of all, I just want to make clear that the legislature did not say anything that is contrary to either science or even what plaintiffs have argued here. Plaintiffs aren't even challenging the personhood provision. They elected not to. So this notion that somehow that what the legislature found is different from what we believe or experts are going to say, I think is just wrong. I mean, they basically said, look, this is a unique, separate individual. Granted, pregnancy is a unique human condition, and it's dependent on the mother, of course, as it's going to be throughout pregnancy, and it's only advances in modern science that allow some babies to survive, from 22 and a half-ish weeks on in certain circumstances with very, intensive care. So I don't think that there's any differentiation between what the legislature found and what we're arguing, or what is essentially, as far as I can tell, undisputed. The argument seems to be that because embryos and fetuses are small, and dependent, that somehow this changes their moral status. And we disagree on that, but the key point is that the legislature gets to make that determination. And by and large, it's just a tautological argument from the other side, which says, well, there is this right to abortion, therefore the legislature doesn't get to make that determination. But I don't think that really gets you anywhere. On Pavicic being somehow just about taking a picture, the point in Pavicic was not simply that someone took a picture, it was that they then used that picture and that likeness without this person's consent. And the difference between, of course, Pavicic and here is that no one else was implicated in Pavicic. There was no third party, no neighbor, no one else that was being affected by this. On miscarriage, I think the statute's very clear. Our primary point on this is that you are not intending to end the pregnancy if you're dealing with a miscarriage. I mean, that is our view of the statute. I don't really know what other view you could have of the statute, but so I don't actually think we disagree with the plaintiffs on this point, so I won't spend too much time on that. I also want to push back on this notion of least restrictive means or narrow tailoring. It is true that in one portion of PAL it uses that language, but it doesn't say that's the only test that applies, and in fact it cites to cases with both tests, and earlier in the opinion it uses the very language that I said, not unduly oppressive.
I figured your language is in there as well. It just leaves a poor little Superior Court judge wondering, well, what text am I supposed to use?
I mean, I don't think it ultimately matters, because I think that either way, the interest of the state in protecting unborn children is a compelling interest, and I think that the fundamental disconnect between us and the plaintiffs on what's the least restrictive means is it is not narrowly tailored or the least restrictive means to just not prohibit the thing that you're trying to prohibit. It's no more narrowly tailored to say we're going to let you do this in certain circumstances up to 20 weeks than to just stop it at 6 or 8 weeks. You're just talking about, well, how, at which point are we protecting our interest? It's not like you're still protecting it if you're letting this happen for months on end. And then on the psychiatric point, again, this is really a question for the legislature, but again, the plaintiffs have never even responded to our basic point that the legislature, of course, can determine that certain things you cannot do in order to deal with psychiatric emergencies. It's not to denigrate the seriousness of them or to say that they're somehow not relevant. It's just that in the same way that we wouldn't let someone commit a crime of some other sort in order to deal with their psychiatric issues, we're not going to let them commit this particular crime because we think that there are much better and other ways of solving that problem. And again, that's what legislatures do. They regulate in this area all the time. Finally, I think one of the things that, on the motion to dismiss, one of the things the plaintiffs raise is this sort of, it's not clear what doctors can do and what they can't. We, of course, disagree with that, but also they didn't bring a vagueness challenge. This isn't a vagueness case, so I don't really see how that's relevant. And then I'm a little confused on the notion that if in one circumstance this law were invalid as applied, somehow the entire law is invalid. I confess I don't entirely understand this argument. Normally what the judiciary tries to do is keep as much of a statute around as it can, not look for reasons to sort of like, got you, you didn't quite get that one point, so we're going to get rid of the rest of the statute. And then finally, on void ab initio, I don't think we disagree with the plaintiffs on the technical point of what the legislative history of the law in Adams was, but we do disagree very strongly on what the court was referring to when it said court interpretations of that period. I think if you look at that paragraph in context, it's talking about before the Equal Protection Clause was even added. But I also, even that dispute is getting very far away from the core point here, which is plaintiffs say precedent somehow compels this conclusion and yet can't find a single precedent ever of a court ever doing this. And the best they have is this one line in Adams where the court didn't even do it. It said we don't have to look at that analysis. And the court certainly didn't say that overruled judicial opinions would somehow matter. So I don't want to belabor those points because we have briefed them many times, but I do want to just, of course, remind the court they cannot come up with a single instance of any court in 250 years in any state or federal court doing this, and it's because it's just fundamentally at odds with the way that legal proceedings work. I'm, of course, happy to answer any other questions that the court has. Otherwise, I just wanted to make those few points.
I have one question, and it can be fleshed out more during the trial and argument afterwards. Folks have stayed pretty far away from equal protection. It's alleged. It's not as fleshed out as I thought maybe it would be. What is your response to an argument that one constitutional flaw with that medical exception provision is that it doesn't provide equal protection? If I am suffering from a mental health condition that might cause me to, I want to make sure I get the right language. harm one of my major bodily functions through self-harm because of the mental or emotional impact of moving forward with a pregnancy, and that's too bad for me. But if for physical health reasons, a major bodily function of mine would be irreversibly, permanently impaired, whatever the magic language is, that is an exception. How is that not an equal protection violation of that particular provision? So we don't need to get to privacy right. There are some exceptions built into it, but they don't seem to apply equally.
Yeah, so Your Honor, on equal protection more generally, the reason I think that neither side has really gotten into it is their only argument seems to be, well, this is a fundamental right, therefore it violates equal protection, but if it's a fundamental right, we don't really need to get to equal protection. But on your specific question, so the way equal protection analysis works is that there are several steps. First, you have to prove you're similarly situated. Then, to get anything beyond rational basis review, you have to establish that there's a fundamental right at issue or that you're part of a suspect class. I don't think either of those could apply here, and so we're at rational basis review at most, but we're not even there because they're not similarly situated. There are numerous circumstances where we allow someone, in fact, it's the prescribed treatment for a particular physical ailment is medical intervention, surgery, or something like that. But we wouldn't let you do the same thing just because you have a psychiatric issue. So if you have some sort of problem with one of your organs that needs surgery, you can get surgery. If you just think you have a problem with one of your organs, but you don't, it's entirely appropriate for the legislature to say, you doctor cannot do that. That's not the appropriate way of responding to that. So I think, again, not diminishing the real seriousness of mental health problems, they're just not the same as physical problems. They're not worse or better, they're just different. And so you're not similarly situated in those circumstances.
Okay, we'll explore it more. Thank you. All right. My thought was that I guess I need to know from counsel for plaintiff how you wanted to start. I don't need to take a break yet. We can because we're transitioning to doing the trial. If you want to do a short break, otherwise I figured we'd go closer to 11 before we break. I've got timers here I can use. I wasn't sure if we should do 6 hours or 7. I don't know that there are 14 hours of business time between now and when I kick everyone out tomorrow. I'm happy to do 7 so that we don't run out of timer time, but we still have clock time. So I don't know how you all discussed that. I know I had sent through Ms. Niles a little bit of pushback when I did the math. We will take some breaks during both days, so I didn't quite get to 14 business hours.
Your Honor, we are fine to not take a break now and just dive into it. And I think we had planned, given your instructions, to be aiming for 6 hours.
Okay. Well, if we have extra time, that'll just be a bonus for everyone.
And one preliminary thing that we have conferred with the state beforehand in an attempt, and a lot of things, to try to streamline the next 2 days. And one of the things that we agreed was that each side was not going to have any objections to the other's exhibits. So if it's okay with you, we would go ahead and move to admit all of plaintiff's exhibits, and I believe the state's going to do the same on their side.
So no objections to disclosed exhibits. If something comes up, now that this witness has said this, we have bonus exhibit. We were at like 500 on the state side. So bonus exhibit 501, that may be subject to an objection because neither side has had a chance, the opposing side hasn't had a chance to vet it.
Correct. This applies to everything on our disclosed exhibit list.
Okay, so I have a handy dandy binder you provided that has for plaintiffs a very short witness list, a very long exhibit list, although not as long. 148 plaintiffs exhibits.
Yes.
Okay. Let me. And the defendant's exhibit list has 524 exhibits. They win. It's more exhibits. Let's go home. This is way more exhibits. So there are no objections from plaintiffs to the 524 exhibits on the defendant's list.
Correct.
You've actually looked at all of them.
No.
Close enough. All right. And Mr. Scher, any objection? And I'm not ignoring you, Mr. Petrani, but you mentioned Mr. Scher and
Yes, Your
crew.
Honor, from this point on, it's not that I'll never speak, I might never speak, but I think the default is going to be either Mr. Scher or one of my colleagues.
Okay, I'll start with Mr. Scher and he can redirect me. Mr. Scher, no objection from defendant to the admission of and consideration of the 148, assuming they didn't leave any out, plaintiff's exhibits.
That's correct, Your Honor.
Okay, great. Well, that will certainly streamline things. So when you're ready,
All right, I'm going to turn it over to Miss Rebecca Chan.
Ms. Chan, and I'm assuming everyone, there's some new names I didn't remember signing pro hoc orders on. I don't have an issue with people coming in and arguing from either side. There are no objections from plaintiff to any of the lawyer names you heard on defendant's side.
No, Your Honor. And I believe everybody on our side has had their pro hoc submitted.
Okay, and Mr. Scher, you have no concerns about that either?
No, we don't.
Great, okay.
They'll accept our defendant's exhibit attorney, then we're happy. to
Excellent.
accept the pro hoc for all of it.
All right, Ms. Chan,
Good morning, Your Honor.
good morning.
Plaintiffs call Dr. Carrie Swiak to the stand.
All right. And before we get started, your clock hasn't begun running yet. Will you be sharing exhibits digitally? So we need Dr. How do you say your last name?
Swiak.
Swiak's screen to be working?
Yes.
Great. So before you get sworn in, will you
Tap the got it button. Does it say got it? That blue. Excellent. Okay.
And let me do one other thing. There we go. Okay. Boy, when it's surgery time, you know, where right and left is. It was my left hand, doctor.
Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Good Lord, in the United States, spell your name for the record.
Carrie, C-A-R-R-I-E. Last name is Swiak, C-W-I-A-K. Good morning, Dr. Swiak. Oh,
Very good.
A good start. Should we try again? Good morning, Dr. Swiak.
good morning.
As you're aware, the court has previously admitted into evidence your two affidavits that you submitted in this case on July 26th and October 14th, 2022, respectively, as well as a current copy of your CV. So I'd like to just briefly go through some of your credentials now. What's your current profession?
So I am a professor of obstetrics and gynecology, as well as a professor of epidemiology.
The second one was epidemiology.
Yes.
Could you briefly describe your educational history for the court?
I received my medical degree from St. Louis University School of Medicine. I completed a residency in obstetrics and gynecology at the University of Connecticut Health Center. I completed my fellowship in complex family planning at Emory University and also completed my master's in public health in epidemiology at Emory University.
Are you board certified in any particular field of medicine?
Yes, I'm board certified in obstetrics and gynecology and board eligible in complex family planning.
And how long have you been certified in obstetrics and gynecology?
Well, I've been practicing obstetrics and gynecology for over 21 years now. In terms of when I was actually certified, it was probably 20 years since then.
And are you currently licensed to practice medicine then?
Yes,
In which state?
in the state of Georgia,
And where are you currently employed?
at Emory University.
How long have you worked?
Miss
at
Jan, I need you to speak up or get closer to the microphone.
Sorry about
You're like
that.
behind it.
Is this better?
Is it on?
Can you speak again?
Hold on one sec. What color?
Now it's on. Is this better?
Okay. Yes, much better. Thank you so much. Sorry for the interruption, Your Honor.
Not at all. Okay.
No, that's exactly what you're supposed to do, stenographer April. Why don't you bend there you go. Excellent.
Okay, is this still okay?
This should be better.
Much better. Thank you.
Great. And how long have you worked at Emory?
So again, 21 years.
And you briefly mentioned a little bit, but could you state the position that you hold at Emory?
So I am the Chief of Obstetrics and Gynecology at Emory University Hospital Midtown. I am the Chief for our Obstetrics and Gynecology inpatient service line for Emory Healthcare for our 3 obstetric hospitals. I am the Director of the Division of Complex Family Planning and the Fellowship of Complex Family Planning.
And when you mentioned earlier that you're a professor of obstetrics and gynecology and of epidemiology, is that also at Emory?
Yes.
What does your work as a professor of obstetrics and gynecology entail?
So for me, that does include seeing patients. I also teach a variety of learners, students, residents, fellows. I do research, clinical research, as well as public health research, and teach, so provide lectures, as well as administrative tasks, like in clinical operations, in my duties as Chief of Service.
And what topics do you teach?
So my focus, my expertise is contraception and abortion care, and especially those areas of care for complex patients.
And do you train students, residents, and fellows in the provision of abortion care and miscarriage care?
Yes, certainly. They are, we teach them in a didactic situation where, we may be providing a lecture, perhaps a simulated situation where we're doing hands-on training where they get to practice the skills, whether that be counseling or providing a surgery. They get to shadow us when we are taking care of patients, and then as their competency progresses, they get to engage in that care of taking care of patients.
What is a complex patient? You mentioned your specialty involves complex patients.
Yeah, so for contraception and abortion, it's really something that any obstetrician gynecologist can provide. Complex family planning is a unique subspecialty in which we're more apt to be dealing with and more experienced in dealing with patients with chronic medical conditions, complexities of their anatomy, certainly more likely to be providing care in second trimester. So for patients who are more complex instead of straightforward in their care,